The name of the book is Business Law. It was published by M.C. Kuchhal in the year 2016. This subject is mainly studied in BCom program, first year, second semester. Chapter 1: Nature and Kinds of Contracts. Introduction. The law of contract is the foundation upon which the superstructure of modern business is built. It is applicable not only to business community but also to others. Every one of us enters into a number of contracts almost every day, and most of the time we do so without even realizing what we are doing from the point of law. A person seldom realizes that when he entrusts his scooter to the mechanic for repairs, he is entering into a contract of bailment. Or when he buys a packet of cigarettes, he is making a contract of the sale of goods. Or again, when he goes to the cinema or to see a movie, he is making yet another contract, and so on. Besides, the law of contract furnishes the basis for the other branches of business law. The enactments relating to sale of goods, negotiable instruments, insurance, partnership, and insolvency are all founded upon the general principles of contract law. That is why the study of the law of contract precedes the study of all other subdivisions of business law. The Indian Contract Act 1872. The law of contract in India is contained in the Indian Contract Act 1872. It extends to the whole of India except the state of Jammu and Kashmir and came into force on the first day of September 1872. The act is non-exhaustive. It does not deal with all the branches of the law of contract. There are separate acts which deal with contracts relating to negotiable instruments, transfer of property, sale of goods, partnership, insurance, etc. Again, the Act does not affect any usage or custom of trade. Section 1. A minor amendment in Section 28 of the Act was made by the Indian Contract Amendment Act 1996. Definition of contract. According to Section 2H of the Indian Contract Act, an agreement enforceable by law is a contract. A contract, therefore, is an agreement the object of which is to create a legal obligation, that is, a duty enforceable by law. From the above definition, we find that a contract essentially consists of two elements, an agreement and legal obligation, that is, a duty enforceable by law. We shall now examine these elements in detail. Number 1. Agreement. As per Section 2E, every promise and every set of promises forming the consideration for each other is an agreement. Thus, it is clear from this definition that a promise is an agreement. What is a promise? The answer to this question is contained in Section 2B, which defines the term when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. An agreement, therefore, comes into existence only when one party makes a proposal or offer to the other party, and that other party signifies his assent, that is, gives his acceptance thereto. In short, an agreement is the sum total of offer and acceptance. On analyzing the above definition, the following characteristics of an agreement become evident. A. Plurality of persons. There must be two or more persons to make an agreement because one person cannot enter into an agreement with himself. B. Consensus ad idem. Both the parties to an agreement must agree about the subject matter of the agreement in the same sense and at the same time. Number 2. Legal obligation. As stated above, an agreement to become a contract must give rise to a legal obligation, that is, a duty enforceable by law. If an agreement is incapable of creating a duty enforceable by law, it is not a contract. Thus, an agreement is a wider term than a contract. All contracts are agreements, but all agreements are not contracts. Agreements of moral, religious, or social nature. Example, a promise to lunch together at a friend's house or to take a walk together are not contracts because they are not likely to create a duty enforceable by law for the simple reason that the parties never intended that they should be attended by legal consequences. In business agreements, the presumption is usually that the parties intend to create legal relations. Thus, an agreement to buy certain specific goods at an agreed price. Example, 100 bags of wheat at rupees 1430 per bag is a contract because it gives rise to a duty enforceable by law. And in case of default on the part of either party, an action for breach of contract could be enforced through a court provided other essential elements of a valid contract as laid down in section 10 are present. Namely, if the contract was made by free consent of the parties competent to contract for lawful consideration and with a lawful object. Thus, it may be concluded that the Act restricts the use of the word contract to only those agreements which give rise to legal obligation between the parties. It will be appropriate to point out here that the law of contract deals only with such legal obligations which spring from agreements. Obligations which are not contractual in nature are outside the purview of the law of contract. For example, obligation to maintain wife and children, status obligation, obligation to observe the laws of the land, and obligation to comply with the orders of a court of law do not fall with the scope of the Contract Act. Saldom has rightly observed, the law of contracts is not the whole law of agreements, nor is it the whole law of obligations. It is the law of those agreements which create obligations and those obligations which have their source in agreements. Essential elements of a valid contract. A contract has been defined in section 2H as an agreement enforceable by law. To be enforceable by law, an agreement must possess the essential elements of a valid contract as contained in sections 10, 29 and 56. According to section 10, all agreements are contracts if they are made by the free consent of the parties competent to contract for a lawful consideration with a lawful object, are not expressly declared by the Act to be void, and where necessary satisfy the requirements of any law as to writing or attestation or registration. As the details of these essentials from the subject matter of our subsequent chapters, we propose to discuss them in brief here. The essential elements of a valid contract may be summed up as follows. Number 1, offer and acceptance, and number 2, intention to create legal relations. Number 1, offer and acceptance. There must be a lawful offer and a lawful acceptance of the offer, thus resulting in an agreement. The adjective lawful implies that the offer and acceptance must satisfy the requirements of the Contract Act in relation thereto. Number 2, intention to create legal relations. There must be an intention among the parties that the agreement should be attached by legal consequences and create legal obligations. Agreements of a social or domestic nature do not contemplate legal relations, and as such they do not give rise to a contract. An agreement to dine at a friend's house is not an agreement intended to create legal relations and therefore is not a contract. Agreements between husband and wife also lack the intention to create legal relationship and thus do not result in contracts. Illustrations. Part A. M promises his wife N to get her a sari if she will sing a song. N sang the song but M did not bring the sari for her. N cannot bring an action in a court to enforce the agreement as it lacked the intention to create legal relations. Part B. The defendant was a civil servant stationed in Ceylon. He and his wife were enjoying leave in England. When the defendant was due to return to Ceylon, his wife could not accompany him because of her health. The defendant agreed to send her £30 a month as maintenance expenses during the time they were thus forced to live apart. She sued for breach of this agreement. Her action was dismissed on the ground that no legal relations had been contemplated and therefore there was no contract. Number 3. Lawful consideration. The third essential element of a valid contract is the presence of consideration. Consideration has been defined as the price paid by one party for the promise of the other. An agreement is legally enforceable only when each of the parties to it gives something and gets something. The something given or obtained is the price for the promise and is called consideration. Subject to certain expectations, gratuitous promises are not enforceable at laws. The consideration may be an act, doing something, or forbearance, not doing something, or a promise to do or not to do something. It may be past, present, or future, but only those considerations are valid which are lawful. Number 4. Capacity of parties. The parties to an agreement must be competent to contract, otherwise it cannot be enforced by a court of law. In order to be competent to contract, the parties must be of the age of majority and of sound mind, and must not be disqualified from contracting by any law to which they are subject. Section 11. If any of the parties to the agreement suffers from minority, lunacy, idiocy, drunkenness, etc., the agreement is not enforceable at law. Number 5. Free consent. Free consent of all the parties to an agreement is another essential element of a valid contract. Consent means that the parties must have agreed upon the same thing in the same sense. Section 13. There is absence of free consent if the agreement is induced by number 1. Coercion, number 2. Undue influence, number 3. Fraud, number 4. Misrepresentation, or number 5. Mistake. Section 14. If the agreement is vitiated by any of the first 4 factors, the contract would be voidable and cannot be enforced by the party guilty of coercion, under influence, etc. The other party, that is the aggrieved party, can either reject the contract or accept it, subject to the rules laid down in the Act. If the agreement is induced by mutual mistake which is material to the agreement, it would be void. Section 20. Number 6. Lawful object. For the formation of a valid contract, it is also necessary that the parties to an agreement must agree for a lawful object. The object for which the agreement has been entered into must not be fraudulent or illegal or immoral or opposed to public policy, or must not imply injury to the person or property of another. Section 23. If the object is unlawful for one or the other of the reasons mentioned above, the agreement is void. Thus, when a landlord knowingly gets a house to a prostitute to carry on prostitution, he cannot recover the rent through a court of law. Number 7. Writing and registration. According to the Indian Contract Act, a contract may be oral in writing, but in certain special cases, it lays down that the agreement to be valid must be in writing or and registered. For example, it requires that an agreement to pay a time-barred debt must be in writing, and an agreement to make a gift for natural love and affection must be in writing and registered. Section 25. Similarly, certain other acts also require writing or and registration to make the agreement enforceable by law, which must be observed. Thus, number 1. An arbitration agreement must be in writing as per the Arbitration and Conciliation Act 1996. Number 2. An agreement for a sale of immovable property must be writing and registered under the Transfer of Property Act 1882 before they can be legally enforced. Number 8. Certainty. Section 29 of the Contract Act provides that agreements, the meaning of which is not certain or capable of being made certain, are void. In order to give rise to a valid contract, the terms of the agreement must not be vague or uncertain. It must be possible to ascertain the meaning of the agreement, for otherwise it cannot be enforced. Illustration. A agrees to sell B 100 tons of oil. There is nothing whatever to show what kind of oil was intended. The agreement is void for uncertainty. Number 9. Possibility of performance. Yet another essential feature of a valid contract is that it must be capable of performance. Section 56 lays down that an agreement to do an act impossible in itself is void. If the act is impossible in itself, physically or legally, the agreement cannot be enforced at law. Illustration. A agrees with B to discover treasure by magic. The agreement is not enforceable. Number 10. Not expressly declared void. The agreement must not have been expressly declared to be void under the Act. Sections 24 to 30 specify certain types of agreements which have been expressly declared to be void. For example, an agreement in restraint of marriage, an agreement in restraint of trade, and an agreement by way of wager have been expressly declared void under sections 26, 27 and 30 respectively. Before dealing with the various essentials of a valid contract one by one in detail, it will be appropriate to discuss the kinds of contracts first, because we shall be using the terms like voidable contract, void agreement, etc. very often in the course of our discussion. Kinds of contracts. Kinds of contracts from the point of view of enforceability. From the point of view of enforceability, a contract may be valid or voidable, or void or unenforceable or illegal. Number 1. Valid contract. A valid contract is an agreement enforceable by law. An agreement becomes enforceable by law when all the essential elements of a valid contract as enumerated above are present. Number 2. Voidable contract. According to section 2(1), an agreement which is enforceable by law at the option of one or more of the parties thereto, but not at the option of the other or others, is a voidable contract. Thus, a voidable contract is one which is enforceable by law at the option of one of the parties, until it is avoided or rescinded by the party entitled to do so by exercising his option in that behalf, is a valid contract. Usually, a contract becomes voidable when the consent of one of the parties to the contract is obtained by coercion, undue influence, misrepresentation, or fraud. Such a contract is voidable at the option of the aggrieved party, that is, the party whose consent was so caused, sections 19 and 19a. But the aggrieved party must exercise his option of rejecting the contract, number 1, with a reasonable time, and number 2, before the rights of third parties intervene. Otherwise, the contract cannot be repudiated. Illustration: A threatens to shoot B if he does not sell his new Bajaj bike to A for Rs 2000. B agrees. The contract has been brought about by coercion and is voidable at the option of B. Number 3. Void contract. Literally, the word void means not binding in law. Accordingly, the term void contract implies a useless contract which has no legal effect at all. Such a contract is a nullity, as for there has been no contract at all. Section 2J defines a contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. It follows from the definition that a void contract is not void from its inception, and that it is valid and binding on the parties when originally entered, but subsequent to its formation it becomes invalid and destitute of legal effect because of certain reasons. For example, a valid contract is transformed into a void contract in the following situations. Part A. Supervening impossibility. Section 56. A contract becomes void by impossibility of performance after the formation of the contract. For example, A and B contract to marry each other. Before the time fixed for the marriage, A goes mad. The contract to marry becomes void. Part B. Subsequent illegality. Section 56. A contract also becomes void by subsequent illegality. For example, A agrees to sell B 100 bags of wheat at Rs 1650 per bag. Before delivery, the government bans private trading in wheat. The contract becomes void. Void agreement. An agreement non-enforceable by law is said to be void. Section 2G. Thus, a void agreement does not give rise to any legal consequences and is void ab initio. In the eye of law, such an agreement is no agreement at all from its very inception. There is absence of one or more essential elements of a valid contract, except that of free consent in the case of a void agreement. Thus, an agreement with a minor is void ab initio as against him, because a minor lacks the capacity to contract. Similarly, an agreement without consideration is void ab initio, of course with certain exceptions as laid down in section 25. Certain agreements have been expressly declared void in the Central Act. Example, agreements which are in restraint of trade or of marriage or of legal proceedings, or which are by way of wager. A void agreement should be distinguished from a void contract. A void agreement never amounts to a contract, as it is void ab initio. A void contract is valid when it is entered into, but subsequent to its formation, something happens which makes it unenforceable by law. Notice that a contract cannot be void ab initio and only an agreement can be void ab initio. Obligation of person who has received advantage under void agreement on contract that becomes void. In this connection, section 65 lays down that when an agreement is discovered to be void or when a contract becomes void, any person who has received any advantage under such agreement or contract is bound to restore it or to make compensation for it to the person from whom he received it. Unenforceable contract. An unenforceable contract is one which is valid in itself but is not capable of being enforced in a court of law because of some technical defect such as absence of writing, registration, requisite stamp, etc., or time barred by the law of limitation. For example, an oral arbitration agreement is unenforceable because the law requires an arbitration agreement to be in writing. Number 5. Illegal or unlawful contract. The word illegal means contrary to law and the term contract means an agreement enforceable by law. As such, to speak of an illegal contract involves a contradiction in terms because it means something like this: an agreement enforceable by law and contrary to law. There is apparent contradiction in terms. Moreover, being of unlawful nature, such an agreement can never attain the status of a contract. Thus, it will be proper if we use the term illegal agreement in place of illegal contract. An illegal agreement is void ab initio. An agreement is illegal and void if its object or consideration, Part A, is forbidden by law, or Part B is of such a nature that, if permitted, it would defeat the provisions of any law, or Part C is fraudulent, or Part D involves or implies injury to the person or property of another, or Part E, the court regards it as immoral or opposed to public policy, section 23. Thus, an agreement to commit murder or assault or robbery or to make a gift in consideration of illicit intercourse would be illegal and void ab initio. Illegal and void agreements distinguished. Despite the similarity between an illegal and a void agreement, that in either case the agreement is void ab initio and cannot be enforced by law, the two differ from each other in the following two respects. Number 1. An illegal agreement is narrower in scope than a void agreement. And illegal agreements are void. All illegal agreements are void, but all void agreements are not necessarily illegal. The object or consideration of an agreement may not be contrary to law, but may still be void. For example, an agreement with a minor is void as against him, but not illegal. Again, an agreement the terms of which are uncertain is void, but such an agreement is not illegal. Number 2. An illegal agreement is wider in effect in relation to collateral transactions than a void agreement. When an agreement is illegal, other agreements which are incidental or collateral to it are also tainted with illegality, hence void, provided the third parties have the knowledge of the illegal or immoral design of the main transaction. The reason underlying this rule is that no person shall be allowed to invoke the aid of the court if he is himself implicated in the illegality. On the other hand, when an agreement is void but not illegal, agreements which are collateral to it are not invalidated and remain valid. Illustration. Part A. A engages to murder C and borrows rupees 5,000 from D to pay to B. B is aware of the purpose of the loan. Here the agreement between A and B is illegal and the agreement between A and D is collateral to an illegal agreement. As such, the loan transaction is illegal and void and D cannot recover the money. But the position will change if D is not aware of the purpose of the loan. In that case, the loan transaction is not collateral to the illegal agreement and is a valid contract. In the above case, if A borrows from B to pay his wagering debts, a wagering agreement is void under section 30. The contract between A and B would not have been effected even though B is aware of the purpose of the loan because an agreement collateral to a void agreement is perfectly valid. Kinds of contracts from the point of view of mode of creation. From the point of view of mode of creation, a contract may be express or implied or constructive. Express contract, where both the offer and acceptance constituting an agreement enforceable at law are made in words spoken or written. It is an express contract. For example, A tells B on telephone that he offers to sell his car for rupees 80,000 and B in reply informs A that he accepts the offer. There is express contract. Implied contract, where both the offer and the acceptance constituting an agreement enforceable at law are made otherwise than in words, that is, by acts and conduct of the parties. It is an implied contract. Thus, where a coolie in uniform takes up the luggage of B to be carried out of the railway station without being asked by B, and B allows him to do so, then the law implies that B agrees to pay for the services of A, and there is an implied contract. Similarly, where M, a professional shoe shiner, starts polishing the shoes of N without being requested to do so, and N allows M to polish his shoes, knowing that M expects to be paid for the service, there comes into existence an implied contract, and N is under obligation to pay to M. Number 3. Constructive or quasi-contract. Such a contract does not arise by virtue of any agreement, express or implied between the parties, but the law infers or recognizes a contract under certain circumstances. For example, obligation of finder of lost goods to return them to the true owner cannot be said to arise out of a contract even in its remotest sense, as there is neither offer and acceptance nor consent, but it is quasi-contract as per section 71. Section 68 to 72 of the Contract Act describes the cases which are to be deemed quasi-contracts. Kinds of contracts from the point of view of the extent of execution. From the point of view of the extent of execution, a contract may be executed or executory. Executed contract. A contract is said to be executed when both the parties to a contract have completely performed their share of obligation and nothing remains to be done by either party under the contract. For example, when a bookseller sells a book on cash payment, it is an executed contract because both the parties have done what they were to do under the contract. Where only one of the parties to a contract has performed his share of obligation and the other party is still to perform his share of obligation, then also the contract is called executed. For example, M advertises a reward of rupees 1000 to anyone who finds his missing son. B, knowing the offer, finds the missing boy and brings him. As soon as B traces the boy, there comes into existence an executed contract because B has performed his share of obligation and it remains for M to pay the amount of reward to B. This type of executed contracts are also called unilateral contracts because in such contracts only one obligation remains outstanding. The other obligation have been performed at the time of or before the formation of the contract. Number 2. Executory contract. It is one in which both the obligations are outstanding, one on either party to the contract, either wholly or in part at the time of formation of the contract. In other words, a contract is said to be executory when both the parties to a contract have still to perform their share of obligation in toto or there remains something to be done under the contract on both sides. For example, where T agrees to coach R, a pre-medical student, from first day of the next month, and R in consideration promises to pay T rupees 3000 per month, the contract is executory because it is yet to be carried out. Similarly, where M promises to sell his car to N for rupees 1 lakh cash down, but N pays only rupees 10,000 as earnest money and promises to pay the balance on next Sunday. On the other hand, M gives the possession of car to N and promises to execute a sale deed on receipt of the full amount. The contract between M and N is executory because there remains something to be done on both sides. Executory contracts are also known as bilateral contracts. Summary of the chapter: Nature and kinds of contracts. The Indian Contract Act was established in 1872. A minor amendment in Section 28 of the Act was made by the Indian Contract Amendment Act in 1996. An agreement enforceable by law is a contract. There are two elements of a contract. Number one, agreement. Number two, legal obligation. Characteristics of an agreement are: Part A, plurality of persons. Part B, consensus ad idem. The essential elements of a valid contract are: Number 1, offer and acceptance. Number 2, intention to create legal relations. Number 3, lawful consideration. Number 4, capacity of parties. Number 5, free consent. Number 6, lawful object. Number 7, writing and registration. Number 8, certainty. Number 9, possibility of performance. Number 10, not expressly declared void. Kinds of contracts can be divided on different types. Kinds of contracts from the point of view of enforceability. Number 1, valid contract. Number 2, voidable contract. Number 3, void contract. Number 4, unenforceable contract. Number 5, illegal or unlawful contract. Kinds of contracts from the point of view of mode of creation. Number 1, express contract. Number 2, implied contract. Number 3, constructive or quasi-contract. Kinds of contracts from the point of view of the extent of execution. Number 1, executed contract. Number 2, executory contract. Test questions. Question number 1. An agreement enforceable by law is a contract. Discuss the definition and bring out clearly the essentials of a valid contract. Question number 2. All contracts are agreements, but all agreements are not contracts. Discuss the statement explaining the essential elements of a valid contract. Question number 3. The law of contracts is not the whole law of agreements, nor is it the whole law of obligations. Comment. Question number 4. Discuss the essential elements of a valid contract. Question number 5. Distinguish between Part A, void and voidable contracts. Part B, void agreements and void contracts. Part C, void and illegal agreements. Question number 6. Write short notes on the following. Part A, implied contract. Part B, quasi-contract. Part C, executed contract. Part D, bilateral contract. Practical problems. Attempt the following problems giving reasons for your answers. Question number 1. A invites B to a dinner. B accepts the invitation. A made elaborate arrangement but B failed to turn up. Can A sue B for the loss he has suffered? Hint: no. A cannot sue B for the loss he has suffered because the agreement was of a social nature and hence lacked the intention to create legal relationship, one of the essentials of a valid contract. Question number 2. M agrees to pay N rupees 100 and in consideration, N agrees to write for him 100 pages within 5 minutes. Is it a valid contract? Hint: no, it is not a valid contract. It is a void agreement because as per section 56, an agreement to do an act impossible in itself is void.